Okay, good afternoon. It's a real pleasure to be here and find a group of people who also want to spend a whole Saturday talking about surrogacy. Great to find like-minded people. So I'm going to speak today about the European Convention on Human Rights element of surrogacy regulation. So when we talk about forging a legal pathway for surrogacy in Ireland, we have to look at what the constraints on the discretion of the legislature are. And one key constraint is fundamental rights. So when we're making laws, we have to do that in a way that respects the fundamental rights of people. In Ireland, those fundamental rights sources come on the one hand from the Constitution, and Brian's talked a little bit about that. Interestingly, our Supreme Court has said we're not going to do anything about surrogacy. Surrogacy is quintessentially a matter for the Oireachtas. So they've kind of said hands off, which is unusual when it's a constitution that is so interested in family rights. But currently the position is that the courts are not interested, and the Constitution is not really going to be a major constraint. So what we're left with in terms of fundamental human rights is the European Convention on Human Rights. And in recent years, there's been quite a number of cases that have been taken to the European Court of Human Rights, whereby applicants have challenged domestic restrictions on assisted reproduction. And some cases that we're going to talk about in relation to surrogacy. So in terms of forging a pathway for that, the jurisprudence of the European Court of Human Rights is extremely important in terms of forging our domestic legislation. The key provision of the ECHR is Article 8, which you'll see there, which sets out the right to respect for private and family life. And it's those rights that are most significant in this area. So in my paper, I'm going to first of all talk about the ECHR and assisted reproduction in general, and that court's development of the right to become a parent. I'm then going to go on and look at the ECHR and the regulation of domestic surrogacy arrangements. And I'm going to spend most of my time talking about the ECHR and international surrogacy arrangements, because that's actually where the court has been most active. And that's really where the greatest constraint in terms of Irish domestic legislation is going to come from, I would argue. So turning first of all to the ECHR's general approach to assisted reproduction. So as I said, it's Article 8 that's at stake here. And over time, the court has gradually developed this broad concept of the right to become a parent. And that's very significant. So that's the way the court has formulated it. It's a very broad right. It's not a right to engage in procreation. It's a much broader idea of this parental project. And that's kind of very important to the court's understanding of rights in this field. The right has grown up across a range of cases. I'm not going to talk about them in a lot of detail because I want to focus more on the international surrogacy arrangements. But just in brief to mention some of the most important cases. Evans in the UK was one of the earliest cases, which involved a frozen embryo dispute. So essentially you had a couple who'd split up. The woman wanted to use the embryos to have a child. The man objected to that. And the rule in the UK was that you could only use frozen embryos if both partners consented. Ultimately, the court found that the UK was entitled to have that rule because there was a right to be a parent and a right not to be a parent. But very importantly, it recognised that Article 8 protected the right to be a parent, and to be a parent in the genetic sense, because that's what the applicant in that case was concerned with, the right to use her embryos to have a genetically related child. For health reasons, she was no longer able to produce eggs, so that was the only opportunity she could have to have a genetically related child. Dixon in the UK, again, recognised the right in the context of a couple who wanted to have a child through artificial insemination when the male of the couple was in prison. So again, the court recognised the right to become a parent, and to become a parent in the genetic sense. The most important case in this, I would say, is SH in Austria, where we had a challenge to Austria's very restrictive laws on assisted reproduction. Austria is one of the most restrictive regimes in Europe. And in the regime didn't permit egg donation or sperm donation in general. So that was generally speaking not allowed. So in some circumstances, sperm donation was allowed. Egg donation was never allowed. And that case involved a challenge to those restrictions. So in that case, we have a very important statement on the part of the court that specifically the use of medically assisted procreation is protected by Article 8. And you'll see the quotation there, that as such, the choice is an expression of private and family life. And Article 8 applies to that. The court, the Grand Chamber in this case, didn't find a breach of Article 8, but it did sort of saber rattle, it's been described as, and say that, you know, this is a very important area that is moving quickly, and governments need to keep an eye on this. The legislature needs to keep up with these fast-moving developments. And very importantly, what was really essential in this case and in other cases, and you'll see is very important in surrogacy cases, is the margin of appreciation. So the margin of appreciation essentially means the wiggle room that the state has, the discretion it has to make its own policy decision. And in that case, the court found that the margin of appreciation was wide because of the sensitive moral and ethical issues at play, and the lack of consensus across Europe. So one of the most interesting things about assisted reproduction in Europe is that there's not that much agreement. There's very, very different approaches to these issues. Surrogacy being a very good example, so it's entirely prohibited in some countries. It's regulated quite permissively in other countries. But that margin of appreciation is absolutely essential to the way that the court views these cases. Costa and Pavan, again, is a case where the court recognised the right to have a child and to have a healthy child using genetic screening. So again, pushing the reach of Article 8, gradually pushing it out. It's not always the case that the court will find a breach of Article 8, but it is gradually establishing quite a broad right to engage in assisted reproduction. And as I said, within those cases, the margin of appreciation is absolutely essential. Despite the fact that at the moment the states are accorded quite a broad realm of discretion and a broad margin of appreciation. Going on then to look at surrogacy arrangements in particular. So there hasn't yet been a case heard by the court where the applicant has directly challenged a domestic prohibition on a surrogacy, on the practice of surrogacy as a matter of domestic law. However, in one of the leading cases, well, these two linked cases, so Mennesson in France and Le Bassi in France, and they're decided in essentially exactly the same way, they're linked cases. Those cases concerned international surrogacy arrangements, but they also, in passing, talked a bit about domestic rules on surrogacy, and made clear that the states retain a very broad discretion to prohibit domestic surrogacy, or to prohibit surrogacy as a matter of national law. Interestingly, the court surveyed the general national rules on surrogacy across the contracting states. And you'll see there that it commented that it was prohibited in 35 states, expressly authorised in 7 states, and tolerated in 4 states. So there was quite a divergence in approaches across the contracting states. And it noted that there was a very broad margin of appreciation in this regard. So at this stage, in terms of saying, is Ireland entitled to prohibit surrogacy as a matter of domestic law, it probably is, for the purposes of the European Convention on Human Rights. It doesn't seem like the court's close to weighing in and saying surrogacy is something that, as a matter of fundamental human rights, you have to permit. So that seems to be where the court is with regard to substantive domestic law. So it seems like it's easy. It seems like Ireland is left with lots of discretion in this area. Not so, however, because the court's been very active in terms of emphasising the rights of the child when it comes to international surrogacy arrangements. And this is where the real meat of the ECHR case law is. So there have been a number of cases recently where what's been at issue is not a domestic prohibition on surrogacy, but the rules that a state imposes with regard to the recognition of the legal status of the child who's born as a result of an international surrogacy arrangement. Now, this is especially interesting for Ireland because, as you all know, we don't really have much of a domestic surrogacy industry per se. We have quite a lot of Irish couples who go abroad. We have some altruistic surrogacy in Ireland, but very little commercial surrogacy or even expensive surrogacy, we'll say, in Ireland. So the ECHR has a lot to say when it comes to the way you treat those children when they come home from abroad, or in terms of allowing them to come home in the first place. So I'll focus first of all on these two linked cases, the cases of Mennesson in France and Le Bassi in France. Now, as I said, the reasoning is exactly the same. Only Mennesson is available in English, so I'll focus on that one, but they are the same cases, and the reasoning is exactly reflected in each case because the facts were almost exactly identical. So in this case, we have a couple who go to California to have a surrogacy arrangement. So as it's been said earlier on, one of the most permissive US states, very clearly regulated, very clear legal provisions in relation to surrogacy. The commissioning father is the genetic father. The commissioning mother is not the genetic mother. Both parents are the legal parents as a matter of Californian law. They have a pre-birth order in that regard. So as a matter of American law, or sorry, of Californian law, the legal status is perfectly clear. In California, the parents try and have the child registered in the French consulate. Interestingly, they thought they were going to be able to do that because they had heard on the grapevine that other parents had. They were refused recognition at the French consulate. And that's something they complain about later on. They say they're treated differently to other people, and there's been an unfair application of the law. It wasn't an expressly commercial arrangement, it was an expenses-based agreement, but as we've heard, those expenses can be quite high indeed. So the parents have an American passport for the child on the basis of the pre-birth order. An interesting aside is that if a child is born to a surrogate in the US, they get American citizenship, because that's how their citizenship works. So they're able to come home with the child, but they're not able to register the child as the child of the genetic father in France. And the procedural history is extremely complicated. So they go through lots of different steps of French courts. They're actually subject to a criminal investigation at one point, but ultimately that doesn't come to anything on the basis that international surrogacy is not exactly illegal under French law. And at the highest court, they're ultimately refused registration on the basis that it conflicts with an essential principle of French law, because France has one of the most restrictive surrogacy regimes in the world. So surrogacy, even altruistic surrogacy, is entirely illegal in France. It has one of the most strict approaches to it. And the highest court finds that this is an essential principle of French law. It's our public policy that surrogacy is wrong, both for surrogates and for children, and we're standing over that and we're refusing to recognise these children as your children. There's a fine distinction in that they did recognise the American relationship, but they didn't recognise that the children were the children of the commissioning father as a matter of French law. So the parents appeal that to the ECHR. The court finds, applying the proportionality test under Article 8, it finds that the interference is in accordance with law. It finds that it pursues a legitimate aim, so it accepts that the French government has a legitimate aim in promoting its own public policy in this. But the real meat takes place in terms of this idea of whether it's necessary in a democratic society. And the court examines the rights of the people in question. So it focuses on the one hand on the rights of the children and also on the rights of the parents. Importantly, on the margin of appreciation, the court finds that yes, there's a lack of consensus as to surrogacy, and that means a broad margin of appreciation, but it finds that that discretion is narrowed by the fact that your status as a person at law is an important facet of an individual's identity. And for that reason, the margin of appreciation was narrowed. So we have an important move away from the position in other assisted reproduction cases. So that means that the state has to draw a careful balance between the rights of the children and the public policy at hand. So the court goes on to assess the balance that's been drawn by the French state. And on the one hand, looks at the family rights of the parents and looks at the private and personal rights of the children. And very importantly states the essential principle according to which the situation of a child is an issue, the best interests of the child are paramount. So ultimately, in drawing the balance, the state is required to prioritise the best interests of the child. Looking first to the family's rights of the parents, so that their right to family life, the court finds that there isn't a breach, interestingly, because they found that even though there had been a failure to recognise and a refusal to recognise, the practical hurdles faced by the family weren't that significant. So they said, look, as a matter of real life, practical life, you actually were able to live quite happily. You were able to live your lives as a family, so your family rights weren't significantly affected. So that's kind of interesting, because there was quite a low bar set by the court in terms of practical family life. What the court did take issue with, however, was the personal rights of the child. So the fact that the state had refused to recognise those children either as French citizens or as the children of their genetic father. And its decision and its finding of a breach of the convention actually focuses on those personal rights of the children involved. On the nationality side, it says that a contradiction of that nature undermines the children's identity within French society. And as a matter of personal identity, it emphasises the idea that you have a right to your identity, you have a right to have that reflected in law, and there's a very rich convention case law on that anyway. And they say that seriously raises a question as to the compatibility of the situation with the child's best interests. So I think that's such an interesting decision, because it doesn't focus on the practical problems you'd have if you didn't have a legal relationship to your child. It focuses instead on this much more philosophical idea of undermining the personal development of the child through not recognising their status, either as a member of French society or as a legal member of their own family, and as enjoying a genetic relationship to their father. So it's kind of an unexpected result, I think, and that on a gut level you would expect the practical problems to be more important. But in fact, the court's much more philosophical about this and much more concerned with the child's personal identity rights. The other important case I want to flag in terms of international surrogacy arrangements is a somewhat bizarre case of Paradiso and Campanelli. An Italian case where we have an Italian couple who go to Russia for a surrogacy arrangement. Ultimately, subject to, as a result of DNA tests, they find that the father was not the genetic father of the child. His case was that he was the genetic father, and they'd arranged the surrogacy on that basis. But evidence ultimately proved that he was not. And the position of the parents was that there had been a mix-up on the part of the Russian fertility clinic. That, as far as they were aware, this was their child. The court seems slightly sceptical about that, but sort of says, well, we won't really question their best interests. But the bizarre situation they find themselves in is that they come back to Italy with a child that is not related to them at all. So they have no genetic relationship to this child. And the Italian authorities respond to that by treating it essentially as an illegal adoption and taking the child into care. So very early on when they arrive back in Italy, the child's taken into care, procedures are put in place for it to be adopted, and the parents are essentially treated as people who have flouted Italian law on international adoptions. So here we have the court assessing what seems like the ultimate disastrous scenario in a surrogacy arrangement. And it focuses on the question of whether the state's actions are proportionate with regard to its decision to take the child into care, and the consequences that flowed from that. So the court says that the parents, because they didn't have a legal relationship to the children, couldn't argue on rights on behalf of those children, which is sort of a strange approach to take, but for whatever reason, the court decides that the parents have no standing on behalf of the children and focuses instead on the parents' family rights. So we have, again, a decision that looks at the family rights of the parents. Interestingly, it accepts that the parents' family rights are engaged, even though they have no genetic relationship to the children. So they say, you're a de facto family because you did live together for some time, both in Russia and when you came back to Italy. So there is de facto family life here, and there is an engagement of Article 8 of the Convention. And it goes on to examine whether or not the state's actions have been proportionate in view of that. And ultimately concludes that they weren't. So the court says that with regard, again, to the child's best interests, and it reiterates this idea that that's the key principle to assess these cases. So irrespective of the genetic link or the parental link, they say that the removal of the child from the family is an extreme measure that wasn't justified in these circumstances. But the court's decision kind of is very robust in this, and then trails off and says, well, this wasn't proportionate, but that said, we're not telling you to send the child back to the parents. Because at this stage, I think it was 3 years or something since the child had been taken away from them, the child's best interests, of course, had been engaged again in the other direction. So we have this total mess, really, at the end of this case. And that case is now on appeal to the Grand Chamber of the European Court of Human Rights. But an interesting thing to note between those two cases is that in Mennesson we have this very strong focus on the genetic link between the parents and the child, and that's where the French citizenship element comes from. This case finds an Article 8 breach where there's no genetic link at all. So the importance of the genetic link is going to have to be clarified in terms of trying to figure out what the obligations of the contracting states are. I won't talk about this case in any detail, but just briefly to say the court has said that it won't adjudicate on the length of delay in getting a child home. So it's kind of it's willing to allow states have their own procedures for bringing home the children born through surrogacy. But to wrap up, I just want to make a number of comments in relation to those important cases. So first of all, with regard to the international surrogacy arrangements and the impact of those arrangements on the domestic states, it seems that there's very little discretion for the states to refuse to recognise the legal status of children arising from international surrogacy arrangements. Subject to the question of, it's not quite clear what the requirement is with regard to the genetic or non-genetic parents. So it seems that we do have to recognise international surrogacy. It's not clear whether or not we would have to recognise one where there was no genetic link. Briefly, that's important also with regard to the court's wider jurisprudence on travelling to vindicate human rights, which has been an increasing part of the court's discussions in this area. Finally, and I know I'm coming to the very end of my time, briefly to mention the concept of best interests and surrogacy. So the court has said, yes, as a matter of domestic law, you're entirely entitled to prohibit surrogacy, but in international arrangements, we have to look at the best interests of the child. And if they dictate the recognition of the relationship, then that's what you have to do. There's no reason why that very reasoning wouldn't apply in the domestic context as well, right? So you have a domestic arrangement that was illegal. Why is it not the case that the best interest of the child would dictate that the legal status had to be recognised in the domestic context too? So while at the moment the court has said very hands-off the domestic arrangements, to apply the best interests principle robustly, I think we could see that the court would increasingly expect people to enforce the best interest principle by recognising the relationship between the parents and the child, even if that was ultimately a domestic surrogacy arrangement. So that appears to be the constraints imposed by the ECHR and the Irish legislature. If we do ever actually make some laws in this area, which is always questionable, I think these are the issues that will have to be borne in mind. Thank you.